la nueva realidad del sistema judicial. Manuel Hallivis, magistrado del Tribunal Federal de Justicia Administrativa, México. Tauk, Juez Federal, Brasil. Samuel Arias Arzeno, juez de la primera sala de la Suprema Corte de Justicia, República Dominicana. Moderador, Fernando Triana, Uribe y Michelsen, Colombia.
Good afternoon. Exceptional panel that will address several issues which are very important for the practitioners and for the judicial systems of all the inter-American system. We will try to keep our presentation short so can the public will send our questions and or make interventions that will procure a conversatory between all the magistrates here present and me as a moderator to discuss in depth the issues that will be put into the webinar of this afternoon. Our first presentation will be in English and the other two will be in Spanish. So please go ahead and make your questions in either of the 4 official languages of ACIPI, because Caroline is fully fluent in Portuguese, obviously, due to the fact that she is Brazilian. However, she's shy enough to address the public in Portuñol, so she will be speaking in English. That's why I began speaking in English. Therefore, that's basically the way we're going to address this panel. My name is Fernando Triana. I am the former president of ACIPI during 2009 to 2012. Member of the board of directors of ACIPI during 15 years, during 2000 to 2015. And I'm the current president of the ACIPI's Tribunal and member of the Committee of Arbitration, Mediation, and Conciliation of ACIPI. I'm a litigator, practitioner in my country, in Colombia, and partner of Triana, Uribe, Michelsen. So as the first speaker, and not because she's very well known among the Brazilians, but she's the only lady on the panel, we will be addressed at the beginning by Tauk. She's a federal judge in Rio de Janeiro and specialized in the first instance trial court of the intellectual property. She's the currently assistant judge of the Brazilian Supreme Court, and she's a master's of law of the Rio de Janeiro State University, and also a visiting scholar of Columbia Law School. Therefore, I give the floor immediately to Caroline, which will be speaking about the artificial intelligence in the Brazilian federative system of justice and how they came into virtuality with this new reality. Thank you, Caroline, for accepting the invitation of ACIPI, and welcome. Thank you.
Buenas tardes. Good afternoon, everyone. As Fernando said, I'm too shy to speak in Portuguese, so it's better for me and for you that I speak in English, so I'm sorry about that. I want to congratulate ACIPI for organizing this webinar, especially Luis Henrique and Elizabeth Simpson, who invited me, and Maria del Pilar. I am more than happy to be here with our moderator, Fernando Triana, Judge Manuel Hallivis and Judge Samuel Arzeno. I will talk about the new reality of the judicial system in Brazil, and I will make a brief historical evolution of the innovations, and then I will start with our electronic lawsuit that we have here now. More than 80% of all our judicial process is electronic. I will start with that. And then I will talk about the automation of the decision-making process. And then in the end, I will talk about the implementation of the artificial intelligence in our courts. So we will see that even before the pandemic, we had a lot of technological innovations in our courts in Brazil. So first of all, I want to highlight why we have this technological innovations here even before the pandemic, because we have a huge number of lawsuits. We have close to 80 millions of lawsuits here. So we have also 91 courts here. First instance courts and higher courts, all of them together, they are totalized 91 courts. So technological innovations helps us a lot here. That's why we are investing a lot of money and a lot of time on that. So I am a federal judge of a specialized intellectual property trial, first instance trial court. So in this subject, we see that we have a lot of innovations and creations in general using artificial intelligence. For example, artificial intelligence systems writing poems or painting pictures, or even helping in innovations like for materials for COVID-19, like pharmaceutical research, helping pharmaceutical research. So of course, these artificial intelligence innovations arrived also in the judiciary. And in Brazil, these technological innovations in our courts could be organized in 3 stages, and probably it's the same in other countries. The first stage is about our electronic lawsuits, and then the automation of repetitive acts. So we were substituting, changing people for machines in some acts that are repetitive. And then the use of artificial intelligence. So this, of course, it's a trend in several countries around the world. So the first stage, our electronic lawsuits, it means that we have been replacing paper in our courts for electronic judicial process since 2006. We had a law specific about that, and this law told us that we must submit all of our claims to the courts in an electronic way, and also the courts should communicate with the lawyers, and lawyers should communicate with the courts only in electronic ways. And also judges, lawyers, and all the civil servants should sign everything online in our specific portal for that. It's an e-justice portal that we call here. So currently 85% of all our cases across the country, are across our 91 courts that we have here, are filled in a digital form, and they are discussed and decided online. Only the hearings that we still make in person, but everything else we do online. And the second stage after that, after this electronic lawsuits, we started to implement automation of repetitive acts. What does it mean? It means that we started to use technology as a tool to improve practice during the judicial procedures. For example, repetitive tasks or those with low complexity that our public servants use to lose a lot of time doing that, then we replace that, and we replace these persons for machines, And we use these people for more complex tasks. For example, imagine that we have a court judgment and we have to communicate the lawyer about that judgment. Instead of making a staff, for example, a public servant, click on our electronic system to allow this communication, to communicate that court judgment to the lawyers, now we replace this task, and with the server, the public servant doesn't do this anymore. We now use our machine that is programmed in a way that once the judge electronically sign the court judgment, there will be automatically a publication of that act and automatically a communication to the lawyers. So at this stage, there is no use of artificial intelligence to perform these tasks. We just program the system to do some automatic acts, but with no high level of complexity. So we don't need to use artificial intelligence in this stage because they are repetitive acts. But finally, and this is more recent, we've arrived to our third stage of technological innovations using artificial intelligence. And what does this mean? It means that we have been investing a lot of money and time in a lot of artificial intelligence systems to help our judges to decide. So first of all, here in Brazil, at least until now, in all of our systems that use artificial intelligence, any artificial intelligence system is deciding instead of the judges. So there is always only a suggestion made by this artificial intelligence system, and then the judge will reveal this suggestion. The public servant and the judge will reveal this suggestion. So in Estonia, for example, in Europe, we've been hearing that they are planning to create a robot judge that will replace the human being. We don't have this plan here, at least for now, and I think we don't have this discussion here. It's definitely not a plan. So all of our artificial intelligence systems are just helping the judges to decide, but never deciding instead of the judge. So we had the last research we had here. It's our most comprehensive research of artificial intelligence projects in Brazil, in our Brazilian judiciary. It is conducted by our university called Getúlio Vargas University. It is very famous, a very famous university, and it is coordinated by one of our justices from a high court called Luis Felipe Salomão. It is concluded last year, and this research points out that we have now 64 systems that use artificial intelligence among our courts. We have lots of examples. I won't have time to explain, of course, all of these systems, but I will highlight two of them that I think it's very, they have been showing very good results. So when we talk about artificial intelligence, we talk about machines performing tasks in a very close way to a human being. So these intelligent machines work based on algorithms, which are a command for the machine to perform a specific tasks. So the first artificial intelligence system here, their use algorithm that I would like to highlight is one used in our Superior Court of Justice, that we call here Superior Tribunal de Justicia. And this specific system is used to organize groups of similar cases to help judges. So we have a lot of appeals that arrive to this high court, STJ, Superior Court of Justice, and they organize these appeals according to some specific themes that they have or some specific areas, some specific fields, some specific subjects that they have in common. And this helps a lot the judges, the justices, to decide that cases after that. And the second artificial intelligence system, it's very interesting here. It's one that our Supreme Court has been using. It's Brazilian Supreme Court. You probably heard about that, Supremo Tribunal Federal. And this specific system, at least until I think only Brazil has a Brazilian Supreme Court has an artificial intelligence system. And we, as I said in the beginning, we need to have this because we have a huge amount of cases. So we need help. Probably smaller countries don't have so much this big amount of cases, so they don't need to invest on that. But unfortunately, we need to invest on this here. So this specific artificial intelligence system of our Supreme Court, it reads appeals that arrive to the Supreme Court, and it identifies which ones fulfill some procedural requirements to be admitted in the court. So to make it clear, in our Supreme Court, only appeals that are admitted only some appeals are admitted because they have general repercussion. It's repercussão geral in Portuguese. Maybe you understand this better in Spanish. All of our appeals should have general repercussion or repercussão geral. It's a prerequisite to be admitted on the court. So this specific artificial intelligence system, it has a name. It is called Vitor. That is a name of a former justice of the Supreme Court, a very famous former justice here. We decided to give the system his name. And this specific system, Vitor, uses OCR. It's a technology called optical character recognition, which recognizes the characters from an image of the case, and then obtains a text file of that image. And then the system can understand, because the characters can understand that text, and then can see and make a suggestion to the public servant and to the justice if that case has or don't have or don't general repercussion, repercussão geral. So the public servants use it to take around 44 minutes in this task. And now with the system can do the same job in 5 seconds. The system makes the suggestion, oh, this appeal has general repercussion, or this appeal doesn't have general repercussion, in 5 seconds. And then after the suggestion, it is reviewed by the servant and after by the justice. I am almost in the end. So after the pandemic, I would like to highlight just one big change that we've been watching here. Everything that I said, the electronic lawsuits, and then the automation of the decision-making, and then the use of artificial intelligence, all of these stages we were watching before the pandemic, even before the pandemic. With the pandemic, a big change, and of course in your countries are the same, we started to make the hearings online by video conference. And now this major innovation will remain after the pandemic, because our Conselho Nacional de Justiça, our Superior Council of Justice, that creates some rules, some recommendation to the justice. This council have decided that after the pandemic, once it's over, we can still use online hearings in some cases. So if the lawyer wants, he can access what we call here digital court, and all the procedural will be exclusively performed electronically. So not only the submission of the claim and the communication with the court and from the lawyer to the court will be made electronically, but also the hearings will be exclusively by video conference. So this is a choice, optional to the lawyer. He can choose or he can opt out, but it is a huge innovation because we can have a case that starts and ends in electronic way, so online. So this is it. Thank you very much for your attention.
Caroline, thank you to you. Very interesting, your presentation. As I told you before, the idea of this webinar is to have a dialogue about the experience of each judicial system during the pandemic and the use of technology, and how every one of our countries has faced this new reality, the difficulties, the lessons, and opportunities that these changes represent for the judicial system and us as operators and users. So I think your thoughts and your presentation has addressed that exactly. And thank you very much, Caroline, for sharing your experience with us, the participants of this webinar. And now, with your respect and venue, I'll switch to Spanish, as the other panelists today will be speaking in their mother tongue, which is Spanish, and then cambiaré a.
So I'm going to switch to Spanish to tell you that our following panelist and the third one for them, one of them will be speaking in Spanish. And of course, we will have some very interesting topics for you on what we call the new reality of the justice system. Our following panelist is also an exceptional one, Dr. Manuel Hallivis Pelayo, Mexican. He is currently a magistrate of the Superior Room of the and an ex-president of the Tribunal of the court. He is a professor of alma mater of the UAM for more than 40 years, and also a professor in other university centers such as the UP, and also a visiting professor of the University of Salamanca. He also has a magistrate in law and public administration in the University of Tulane and the Michigan University, and a postgraduate studies in Spain. He is a recognized author and has been honored many times in his thesis, and is also a gold medal of Villa Sanchez Senior, and has received awards. Also received the Alfonso el Sabio Medal of the UP in Mexico. He is also the ex-president of many associations and is currently here in our panel. So there you go, Manuel. Thank you very much for being here. Your microphone is turned off. Sorry. Thank you very much, Fernando. I want to thank ACIPI very much, especially Enrique Diaz and Maria del Pilar Troncoso, for your kind invitation to participate in this panel. It is an honor to share this panel with Caroline, Samuel, and Fernando. I would like to start by saying that the essence of my comment is that the courts in Mexico had a positive reaction to the changes of the pandemic, and that this is important to continue to provide a good quality service to everyone, and it's important to protect all the people and the employees from the COVID pandemic. I can say that the evolution has been very positive in how we impart justice, leaving us the possibility of having mixed schemes that are both in person and online that allow for a quality service, using to the maximum the elements that the IT provides us, and the results are visible. But first, I would like to say that in the Federal Court of Administrative Justice, we have a lot of years of effort in this subject, and which has led us to an improvement and to the levels that we now provide and that we want to provide. Since the 90s, we have seen worries in this court about having the elements to prepare for the challenges of the road towards an increase in jurisdiction and competence. It's not just a gradual increase in the quality and competence, it's also having the elements to face in a proper way the big challenge that they had, and in general, for the institution to improve its response capabilities in an exponential way. In that sense, the volume would increase and the difficulty too. We judged the whole administrative aspect, including intellectual property and fiscal property. In 2021, after 2 years of a pilot test, we have an integral system of control of judgments that we wanted to be complete, versatile, useful, with the big volume that we have of the matters that these courts handle. So an automatic handling of this allowed us to save time in these controls that before were done manually. So the central idea was to ease both getting the documents and also the consultation of the system. We're talking about since the 1999, 2000s, and then in 2001, we started to use different tool systems, different messages, and windows that allowed for an easier use. So this allowed the users, the judges, and the people that worked with them to be able to use this system in order to improve the quality of the products. We are talking about 20 years ago, so technology was different. The idea was to implement an automatized system that controlled the whole process with 2 different lines: an integral control of checking in the internet through a website of the court, and then also adopting different templates for different topics designed to simplify the tasks and to allow for an absolute control of the files through control of the notifications and other things, which allowed for an automatic issuing of reports and getting essential information using a concept that we use, taking information. So extracting information that is already in the system, like, for example, the file number, the names of the defendants, etc., the addresses, names of judges, integration of the rooms at the different times, the dates, everything. So once the information is entered and validated, the system retrieves that information, and that allows to check for the correctness of the information and to reduce the amount of errors there, and also concentrate on essential tasks. For the ones that had to do this before, I can tell you that we lost a lot of time on really checking this, and the system didn't really allow us for that. The system really helped us to ease this.
In 2006, we had to thoroughly review the system to try to incorporate the adequations of a new contentious law, which implied modifying a lot of templates, adding about 400 new ones. And technology was used then to try to make our work easier, but also to ensure efficiency, speed, efficacy, basically to comply with all our goals, from simple things such as numbering and file assigning, controlling files, knowing who has made a query and how long they took, up to things like making all data adapted to a reality which can ensure transparency in terms of administrative justice. In 2010, we had to make some changes. We elaborated a strategic plan that was called 2010-2020. And with the exponential increase of all the new cases and the budget restrictions, because we could not assign judges or create new courtrooms, we were running the risk of not meeting the standards that are required when it comes to administrative justice. Therefore, we decided back then, we were part of the higher courts, to promote a number of changes. One of the main ones was to put into operations an online justice systems. We call it a fully online trial. And a summary trial that was for just a few magistrates. We're talking about 3 usually in most cases. And so at the beginning, we created this online trial that went into force in August 2011, exactly 10 years ago. At the beginning, it was only applied in the areas of precisely intellectual properties and online trials. This is a trial that is substantiated and resolved throughout, including the file queries, through something that we called, back then it's still called, an online justice system, which is an IT system that is established by the tribunal to register, control, process, and store, and manage and notify all of the administrative process that we have. So we have an online file that cannot be tampered with and that is safe. This has been the case since 2011. So you can imagine that back then and even today was optional for particular parties, but it was mandatory for the authorities. Sometimes, it's important to understand that we do this for both parties, including authorities. This allows us, this remote promotion system allows us to do remote file queries 24/7. And I would like to emphasize this. This has been the case since 2011. 5 years later, in 2016, we had a reform that was jurisdictional and administrative, that, amongst other things, and I was back then the president of the tribunal, so I can tell you in full detail about that. Well, it set out the universal electronic notification, which means that since 2016, even if the particular party chooses not to go through an online trial, they may still get notifications online, which, together with the shorter deadlines that you can see according to what's shown on the screen, allowed us to significantly reduce the time in which we work with each case. So after this, we have some files that are resolved on average in 2 months. Of course, the others will take up to 8 months to be resolved. I think it's worth pointing out that the consolidation of this implied a stable system that did not lose its updated nature. That's why little after the beginning of the pandemic, we had to build a 2.0 version of online trials. And the starting point of that is the experience that we've collected over 10 years So that right now, this online trial 2.0 does not require a previous registry by users. Everything is done online. They don't need to do it physically. We only work with something that we call advanced electronic signature. Of course, we've made some improvements to the system to make it more user-friendly, more stable, and that we can consolidate the way that we use it to all our users. I'd like to say that the judiciary had a very similar process that was consolidated through a constitutional reform that was published on the 11th of March of 2021 this year in terms of digital justice, which set out the obligation of every tribunal and courtroom in Mexico to implement digital justice systems to substantiate and resolve online every process and jurisdictional procedure. I must say that the federal judicial branch has to work with millions of cases, and the same happens to all local judicial systems. But well, the federal one is particularly important. We resolve on average 180,000 cases a year. So when the pandemic struck, the tribunal, the court had to stop for 15 days from the 15th of March, 17th of March to the 1st of April. And we needed to organize how we were going to deal with the pandemic. In April, we migrated, so I'm talking about April 2020, we migrated to a work from home system that has helped, that was really relatively easy because of the online trial systems in which all the IT systems were really well implemented and developed. And we kept on operating, by the way, with this online trial system. But what we needed to do was to appoint presential people that would work on presential calls. And working from home meant that we were able to telework with all the processes with high productivity, with more than acceptable productivity considering the pandemic. We operated remotely with what we call full administrative decisions that consider all the courts throughout the country, with 62 courtrooms and more than 3,000 public servants. Then we also had to work with all the jurisprudence, and finally with the sections, which are the ones that have to deal with international treaties and where everything that is related to we're talking about more than 200 million Mexican pesos. I don't know what the figure is in US dollars. So the government had to get all of this together, get all these norms together to coordinate the way in which the courts were going to work. We have a federal court that is so big as the system itself, and the meetings of the superior courtrooms are always presential. And because we are decision judges, not instruction judges, we couldn't have face-to-face meetings because of the pandemic. So what we did was to try to find a platform which we ended up working with Google Meet, and that allowed us not only to keep on working with administrative decisions, but also at a certain point we were able to resolve through Google Meet, live streaming with people, also with working on YouTube. We were able to make our hearings public, like, you know, the same as we do with the court sessions, which are broadcast on TV. They have been broadcast on TV for a while, and that is uploaded, and it can be accessed by the public, and inquiries can be made. We had a problem once where we lost audio for a couple of minutes, or I don't remember, it was audio. Sometimes it was the audio, other times was the video. But well, you know, the internet worked really well, and I can say that we had a successful experience, we solved a number of issues, and all the trials of high courts were publicly resolved, in some cases with up to 500 people attending some of our sessions. And of course, with the press regularly attending the sessions because, well, as I said, we have to deal with some very important cases. Then on the 3rd of August, we went back to a semi-presential scheme that was, well, sometimes we had we had some people going 2 or 3 times a week, other people went 2-3 times a week. And considering this experience that I told you about, the IT process, having a fully online electronic trial allowed us to deal with these very heavy issues, especially in regional courtrooms where trials for lower sums of money are dealt with. All the staff teleworked to try to avoid any backlashes with the pandemic, and the key to success, I think, was to consider that we were just confined, that we were in a lockdown, but we were still working. I remember that someone said, we're in a lockdown, not on holidays. So we have to keep on working as if we were at the courtroom, but we're going to do it online. And that allowed us to work from home, and we really got used to it. Of course, a lot of people wanted to go back to face-to-face trials because we were only dealing with urgent cases. Thanks to this, we realized that a lot can be done remotely without affecting productivity, and teleworking allows our staff not to waste so much time commuting. Fortunately, we had already started implementing and designing this 2.0 version that I had talked to you about regarding online trials, which was perfected and went into operations in the 3rd quarter of 2020 in many regional courtrooms, and we've been implementing that throughout Mexico ever since. Additionally, halfway through the pandemic, we designed a new platform that allowed us to present, for those that chose traditional trials instead of online trials, that they could file a complaint and all their evidence online by using a very simple system that allows us to use PDF systems to file the lawsuit without having to register or go directly to the courtroom. So I think it's important to point out that this new face-to-face reality is going to give us even more insights. We've gone back to face-to-face sessions, and in higher courtrooms we're having face-to-face sessions, although we have decided to keep on live streaming them on Google Meet and YouTube and so on and so forth, so that not everybody has to go to the courtroom to be part of a hearing. Also, we need to be really careful because we know that the pandemic is not over. But before, the decisions that we had to make were never-ending discussions, and now we have this new element, which is that now the speaker has to justify their decision in front of the audience and ourselves. So in a few minutes, well, depends on the issue itself, we take some minutes. Well, today I had we have a time limit. That's the bottom line. Especially, for example, if you're live streaming on YouTube, you cannot exceed a certain amount of time. So we're talking about a better justice response. It allowed us to get to know all the IT instruments that we can use for the benefit of our people. And I believe, and allow me to wrap up with this, that I don't think it's crazy to say that this will keep on growing in this direction, because we've improved, and as time goes by, we will keep on perfecting these instruments, and we will have a growing improvement in how we implement and administrate justice. Worldwide, teleworking has allowed us to decongest our cities, to decongest transportation and traffic, to decongest offices, and has allowed people to have better quality of life. But of course, we need to keep in mind what we've said before, that we're not on holidays. It's work from home as much as you can. Thank you very much. I'm honored to be part of this panel.
Gracias, Manuel.
Thank you very much, Manuel. We are the one who are honored for you to participate in this panel. Thank you very much. As I anticipated at the beginning of the presentations, we're going to leave the questions for the end, but I'm sure that both Caroline's and your presentation, Manuel, have generated a series of questions that we would like to address at the end and talk about with you. Since the last ones will be the first ones, dear Samuel, let me present you, let me introduce you to the panel. We are happy to have Samuel Arias Arzeno, who is a judge of the first room of the Supreme Court of Justice of the Dominican Republic. He is also a bachelor in law with honors, and he studied in the University Enrique Sudueña. He also studied in the Oberta University of Catalonia and is currently studying for a PhD in law in the Pontificia Universidad Católica of the Dominican Republic, with joined with the University of Colombia. He is also a professor of law in the Pontificia Universidad Católica of Madrid, and also a professor in the university, in the Autonomous University of Santo Domingo, and also teaches on conflict resolution for judges of peace. He is also an author of books and articles, specialized articles, and he has also been awarded, as well as Manuel, in different occasions, and also Caroline, with different awards in the Dominican Republic. For example, in 2004, for example, for merit and judiciary integrity, and has also won contests of the Pontificia Universidad Católica. So without further ado, Samuel, tell us a bit about this new virtuality, this new reality that you judges have in our dear Dominican Republic. Thank you very much, Fernando. First of all, I would like to thank ACIPI for the opportunity that we're given, especially Maria del Pilar Troncoso, who invited us to participate in this panel. For me, it has been and is a great honor to share with Caroline and Manuel these experiences of how the justice is going, and my colleagues make me, first of all, put into context our guests on what is the reality of the Dominican Republic, because Caroline was talking about artificial intelligence, Manuel was talking about pilot experience of more than 20 years, everything that is IT and the virtual world, the online world, and the Dominican Republic is really not at that level. So the first thing that it's important to point out is that we live in a poor country. It's a poor country that shares an island with one of the poorest countries in the world, which generates a huge immigration from our Haitian brothers to the Dominican territory in search for a better life. And it's calculated that for 2014, around 37% of the inhabitants of our country are poor. Not extreme poverty, but poor within the ranges of the multinational index of poverty. Still, it's important to highlight that we have very little development in terms of technology, technologies and information technologies. It's not that we don't have the instruments. I think that anyone here can have an iPhone 11 without problems, but not having the adequate education, maybe they only use it to make phone calls and to use WhatsApp or any kind of communication system. So the third issue that is internal to the judicial system is the very little resources that the system has to maintain the dynamic of the administration of justice, and especially to develop projects. So according to the law, the justice system, according to the budget, it has the 2.65% of the national budget. But that law is from 2004, and it has never really been complied with until today. So having seen that context, we can say that all the plans for development of technologies and information and communication are contained from the start in what was the strategic plan of the justice system for 2020 to 2024. And for example, if I could read the points that are relevant to what we're talking about, to adequate the infrastructure, to make it more inclusive and more dignified, to serve people using digital media, and to achieve an efficient and trustworthy justice system using TICS. So that was contained within this plan, and logically, projects that could be developed on steps. It was foreseen to implement at least in a middle term, long term, and then we had the pandemic. So it's as simple as that. I was talking with Fernando that there's a very similar reality in Colombia. It's the one we have. And the fact is that simply we were just not prepared for what came. Brazil is talking about artificial intelligence, and Mexico already has 20 years of experience in these things. We simply were surprised by the pandemic, and this made us accelerate processes and imagine what was the shock and the clash of realities that came to be. We found ourselves in situations where now hearings will be virtual ones, for example. One of the big issues is that it wasn't foreseen yet, the development of these projects, and therefore there is a total absence of legislation. We had to have the will of the servers and also the recipients of this. For example, we're going to have a virtual hearing, but what happens if I don't go? What are the consequences of that if it's not foreseen in any text? So those were some of the things that started to clash with the reality. And logically, there was a lot of blocks in the access to justice. In terms of experience, internal experience of the justice system, and specifically talking about the Supreme Court of Justice, we have significant advances that we cannot deny. There's a lot of complaints from the users, but basically in terms of the courts, appeal courts, and first instance courts, But in the Supreme Court of Justice, we've always had a lot of advances thanks to technology. In the first place, telework. The authorities really made sure to provide the necessary equipment to the employees and providing tablets, routers, webcams, so that people could work from home. And in the second place, there's also a pilot process of digitalization. I'm really comfortable in my office right now, and it's amazing that I didn't have to move one single file to place the camera and the tablet in order to communicate with you. I have I've been working this way more than 7 months without a single piece of paper on my desk. I think that that's a big advance. It's not that digitalization is perfect. It's still very rustic, but it has allowed us to work without the need of being in contact with paper all the time. There are approximately 3,600 digital files, and a total like 16,000 that are also on the way. A very big triumph as well has been to have virtual hearings, online hearings. And to provide a bit of context, the presence of the parties wasn't always something that was necessary in this subject. Lawyers came if they wanted. And from that perspective, having a hearing was just a ritual that nowadays is still quite senseless. I hope that with some reforms, some law reforms, we can change this from the hearings that really doesn't really provide much to the development of the case, because the parties have to actually present their requests, their claims in writing. So having said that, since we are a national court, it's very comfortable for a lawyer who is 300 kilometers away to be able to have a hearing without having to go to the home of the Supreme Court of Justice that is in Santo Domingo. One of the big advances that we've had as well is the digital signatures. Wow, for me, that has been really, for me, I love to talk about digital signatures, because for me, I think that in the year and a half that we've been doing it, I've just forgotten how to sign something in person. And it really has been wonderful for us to be able to sign things electronically and for that to reach the users. So I just would like to say, in summary, what are the things that we have as a judicial system? Technology has to adapt to the socio-economical reality of the country. We cannot think that each user, for having an iPhone in his hands, can use it properly to access justice. In the second place, services that are face-to-face services should never, well, in 2 occasions, I was asked what could have been done differently if it had been in my hands to face the pandemic crisis. And I would say that it's to allocate big part of the budget to buying masks, face masks, and alcohol. And I think that there's always going to have we're always going to have a minimum of people providing in-person services, face-to-face services, because for a lot of people, that's the only way of accessing justice. On the other hand, this virtual reality doesn't have to be imposed upon people. Unless we have a legal framework that establishes it this way, I think that this it sells itself. We can't really impose it on people, and that in the long run, people will prefer this. But it has to be a process.
And finally, for the development of technological projects, the judicial branch needs to have an appropriate budget that will allow it to conduct all these projects. Nowadays, it is impossible to carry out a number of these projects, but it goes without saying that this is the right path to try to make progress, because, well, right now in our city, for example, we have a new outbreak, and so we really don't know how much longer we will have to telework and stay, working from home. So I think I've done well with time. I've been timely, so I'd like to thank the possibility of being part of this panel. Thank you, Samuel, for your intervention. That was very interesting, especially from a perspective that is completely different from the Brazilian or the Mexican or even the Colombian realities. Clearly, the issue of virtuality and this new reality in the judicial system goes in keeping with the budget issue. It's about investments. It's about political willingness to make the system work. And that's not always the case in our cases as users of the judicial system. And that's no secret. That's not the case for Mexico or Brazil or the Dominican Republic or Colombia. We know that this is an issue, and this is something that we're trying to fix thanks to working online, but we don't always succeed, with this slowness in the way that we work. So as we get more questions from the public, I'd like to have a short Q&A session or have a conversation with the three of you to try to better depict to our audience a bit more about this reality. So let's start with Caroline.
You spoke about artificial intelligence and the automation in Brazil of several of the procedural acts. I suppose the opening briefs, writs, or the admissions to process, and just what we call rates of pure, I don't know, that do not have enough substance. And I suppose also, because of what you said to us, that has put some speed on the proceedings, that has quickened the proceedings and put the parties many times into trouble to comply with the legal terms, to comply with and carry on the proceedings. But at the end of the day, all these proceedings, even if they speed up, they arrive to the same level. That is to say, they will have to have rulings, and there's no automation, there's no artificial intelligence, I know, that will produce rulings for any judge, because that's precisely the purpose of having you or Manuel or Samuel in the bench. I mean, not normal lawyers, very proactive, very prepared and studied people with the criteria to develop and administer justice for all, as the U.S. Constitution says. So I suppose that at the end of the day, automation, even if it quickens the proceedings, do not solve at the end the problem, which is quick and prompt justice, right, Caroline?
Right, Fernando, I absolutely agree. We have been using a lot of these artificial intelligence systems because we have a huge number of cases. But if we could not use, of course, it would be better. But unfortunately, it's the number is higher and higher, so we don't have option. But as you said, we've been very concerned about the use of artificial intelligence because, as you said, it never replaces the human being that can think about that case, and artificial intelligence only repeats what we saw in the past. It never creates a new solution. Only human beings can reflect and create solutions that are absolutely different from what we've seen in data before, because artificial intelligence works with data, with big data especially. So here in Brazil, we've been creating a lot of principles that have been using around the world to help us to work with this artificial intelligence. For example, transparency and accountability, and make the use only at the last problematic cases. For example, don't use this kind of systems in criminal cases. For example, try to use them only when we are talking about cases that talk about money, for example, but not about, for example, divorce. We don't use this kind of cases. And besides that, I would like to highlight one thing that Samuel said that is very important here for us also, because he said the Dominican Republic is a poor country, but Brazil is also a poor country. We are bigger, but we have similar problems, especially because of our social distance. I forgot how the name in English, but it's desigualdade social. Can you understand that? Social desigualdade. Yeah. So we have a lot of rich people, but a lot of poor people. And 25% of our population don't have access to internet. And 75 of those that have access to internet, they use smartphones, or they use their old, or they don't know how to use internet well to be able to talk to a judge or to do something online with the judge. They prefer the person-to-person contact. So when you talk about virtual justice, I think we should never forget about those people. Otherwise, we will make them more isolate and more exclude than they already are.
Yes, I agree entirely. And then regarding Manuel's presentation sobre la justicia en línea, sobre la audiencia.
On online justice, tell us a bit about how, attorneys and judges have embraced this online trials, because not just because I've suffered from it, but as a judge, I know that there is a certain reluctance from our colleagues and judges and attorneys to these new technologies. Why so? Because we were used for many years to a process that was purely written, then to a process that that tends to be blended, both spoken and written. And virtuality, what it implies is an oral capacity from the person that is from the plaintiff and the judge that receives the information, because we have hearings that cannot be so long because we have obvious technological capacity reasons, and also because it can be really, really tiresome and really, really heavy to deal with. But on top of that, the plaintiff has to, the litigant has to have a number of capabilities that not necessarily everyone has. So that would be my first question to you, Manuel. How have judges and attorneys welcomed this? First of all, I'd like to make a comment. When I talked about the process, online trials has not been around for 20 years. It's been around for 10 years. The 10 years before that, that was part of a comprehensive trial control system, because what was happening was that we had so many cases that we couldn't even do that by hand anymore manually. We've had... well, we basically work in writing, but we do have hearing. And in these hearings, in the trial, with these new substance over form criteria, we have a system by which parties can say, forget about forms, let's just focus on content. And for example, last year I had some hearings in which we had some trials that were conducted online, and people felt really comfortable with that, with being online. But I do agree with a lot of what Samuel said, and let me tell you why. Because so far, online trials can be conducted everywhere in this new version, which came in force in the third quarter last year. But truth be told, people really didn't like it. So we only had about 5,000, 6,000, 7,000 cases a year, plus the ones related to intellectual property. So let's say 20,000 cases. So we had two specialized courtrooms, one that was for IP and another one that was for online trials, where we could conduct different issues and topics. And then interest began to grow, and the 2.0 version had some problems because it was designed in 2010 but went into force in 2011, so it was very dated and it was not so user-friendly. But now with this new 2.0 version, it is absolutely user-friendly. Now I'd like to tell you something a bit about something that we did in 2016. Because something that we need to bear in mind is that online trials are optional. People can just choose to have traditional trials. So what do we do in those cases? In 2016, we had what we called universal electronic notification, which means that you file your complaint as you want, but you have this possibility of, well, when it comes to the notification, any notification that I get will be sent to me by email. And then if I don't have an email address, which is quite unusual, let me tell you that we've never seen a case like that. So what people do is they register their emails and they get the notification, but to prevent them to see that everything is done properly, we create an electronic file where we publish a schedule where we have all the details, and this is something that allows us to those people that don't want to. Now what we can do since last year with this 2.0 version, it allows us to present every single document in PDF. It's getting easier and easier, so more and more people are trusting it. Of course, still now 90% of all the cases are done in a traditional way, but notifications for the last 5 years are 100% online. So the moment that you file your lawsuit or your complaint, everything is notified electronically. So I can have access to anything I want without having to go to the courtroom. You're asking me about the hearings, about, for example, hearings of specialists. That when we decided to go to face-to-face sessions, this was about a month ago, Well, all the specialists were so happy because they didn't have to go to the courtroom and they had their computers at hand, and they could answer any question that they had that we asked them, or maybe one of the parties, to determine their opinion and therefore our decision. So something that we do is, if we see that what we have is not enough to resolve on a case, we have the obligation to try to resolve, always to avoid this back and forth in different instances. So we have this faculty of better providing. And if we believe that the decision of one of the specialists is not too convincing, we ask them to elaborate on the topic, because we need to bear in mind that from the administrative point of view, everything is basically, having to struggle with authority. But intellectual property does have three parts. But let's be honest, complaints related to intellectual property are just concern a certain part of the population, because people of lower income don't have a brand to protect, or a trademark to protect, or a patent. I'd like it to be otherwise, but that's not the case. So we're making a lot of progress in this, and I must say that the judicial branch, once we had so many cases, so many thousands of cases, that they designated two people in terms of the pension law, federal pension law, for public servants, which is, of course, in Mexico, a couple of million people. So they had hundreds of thousands of complaints. So we're talking about maybe 500 different opinions for this, and they concentrated everything on 2 or 3 cases with the help of revising everything online, because otherwise we wouldn't have made it in time, because we say that late justice is denied justice. And so our time of response, when the parties don't appeal, of course, I'm not criticizing anyone.
So when lawyers use this to have their commission, of course, the more instances that there are, it's more convenient for them. But for us as judges, it's quite the contrary. As I said, I have, for example, a judgment that is a very long one, like 1,000-something pages, and now it's online, fortunately. Imagine in this kind of case, how much it costs to have 9 copies of a judgment that is 1,500 pages long. As Samuel says, now we're trying to use paper at a minimum because of the cost that it implies for the country and, of course, for the parties and everything. The fact that they can present, for example, proof via PDF, even in a traditional hearing, in a traditional trial, is really helpful, because anyone has access to one of those offices or those shops where you can buy paper and pencils and everything. And they also have a system where you can digitalize really quickly some things. And therefore, it's really easy for the parties now in the administrative sense to have the elements. And for them, it's really easy. Instead of now having to stand in line to do that, now they can just present it via PDF. So how have the parties reacted? I have to say, Fernando, that they were scared when we suspended the activities in between March and April of last year. They were worried about when the claims were going to be admitted, and when we came back, in a scheme of just in the regional sense. It was only for urgent stuff, but when we opened it, which was in August of last year, then when we started to receive claims again, lawsuits again, we resolved them in an online way. with telework. We took advantage of the situation to try to improve some aspects that were pending. But with those suspensions due to confinement, well, lawyers were really wanting to for us to get the lawsuits, whether it was online, on paper, however it was. I think that it has improved. I think that the pandemic will really teach us a lot, all of us. Samuel also said, and Caroline as well, that we, like the life level of the life standard of a judge who works 14 hours a day, and also their staff on a computer that they can have at home. What's the point of also congesting traffic when we can have mixed systems with which we can comply with stuff? And then, of course, we will have to rely more on the system of, how would I say it? I would say maybe administration based on objectives, maybe not so much on whether they come or not and how many pages were done, but whether or not we can present the judgment in the time that we're allocated for that. Most of us, we end up in zeros at the end of the month, then we have 0 pending projects nowadays, and I think that's the thing. That's very interesting, Manuel. Thank you very much. In this, in terms of comparative law, I think it's very interesting for everyone. And I would also like to say, I don't know what's the reality in Brazil or Mexico, but I would like to have Samuel maybe answer the following question, because what has happened to me personally in Colombia is that before, when I had the need, I can litigate in any city or region of Colombia. I don't know what's the reality in federal states like Brazil or Mexico, but I suppose that it's the same. But what has happened, that with this virtual system, I can do it directly in 15 different places in the country, and I can avoid having this middleman that has to go in person to the local courts. I can do it all myself, and that has also allowed for a standardization of how to do it in the whole country. That has been an experiment that personally I found very enriching, and maybe having someone speak now, I would like talking about that digitalization that Samuel, you say is rudimentary. How have you provided that security for the plaintiff, the parties, and the process itself on proofs and documents, signatures? How have you been able to provide this safety of the documents so that they are not lost, so that they are properly shown to the parties? How have you handled the presentations of experts? And I was talking to you three in private before, and what I miss the most about being in person, or the only thing that I miss about face-to-face hearings, is precisely the testimonies and, for example, the participations of experts, because it allows the plaintiff to ask questions and lawyers to ask questions and understand body language, both you as judges and we as parties, or the witnesses that are providing testimony, to have an interpretation of the gestures of the possible answers, and to see if they are concealing the truth. So Samuel, I would like you maybe in just a few minutes, because we don't have much time left. We have less than 5 minutes left of the panel, for you to explain a bit of that, because that, at least in Colombia, has meant that the parties have resisted to this online process. So I would like you to explain from your perspective and experience how the experience has been in the Dominican Republic. So thank you, Samuel. Thank you very much for the question, Fernando. Firstly, in terms of digitalization, we, precisely because we are starting this whole process, we always have the physical file, some part in the judicial system where we can really check if this digitalization was correct or not. Sometimes we have questions, and in that case, we can simply go to the physical file, the real file, and check it. And as I explained in my room, we have, with the presence of the parties in this case, it's really not that necessary. We just see if they are, if the judgment was okay or not. But we also have issues when we have criminal law issues. We have different principles which imply that the judge that decides on the case has to have contact with witnesses, with the parties, all of that. And they are being done face to face so that we do not break that principle. Thank you very much, Samuel. I think that we have run out of time and we have to finish with the panel. Thank you very much. Thank you very much, Caroline, Samuel, Manuel. It's been a pleasure and an honor to have you here for ACP, for me, and for all the participants in this seminar this afternoon. Thank you very much. Thank you.